1984. This Supreme Court case has been brought up many times throughout this debate, and I should remind you, this was in 1984 when there was not much media, no internet, nothing as we do today, and many things that made the case against be worse for the jurors was the internet, was all the media, was all the coverage that they did not have in 1984. We need to retry this law, create it now, and see how it works in today's society because things are so much different now. The Casey Anthony jurors said they did not want their names released, and they were anyway. It's been brought up that it's the juror's choice, and they can ask the judge to have their names kept private. But the Casey Anthony jurors did not want their names released, and they were against their will, and they were harassed for it. And it was brought up that they can restrict, they're supposed to restrict names as of now on a case-by-case basis. But if that is the case, why is it not done? It is not done enough because jurors are harassed every single day. People we know are harassed because their names are released. So I don't believe this is done enough. And someone brought up that I'm basing this purely on the Casey Anthony case only because it's a high-profile case, and many cases are not like this. And that is my exact point. This happens every day on a local level. It's not just the high-profile cases. It's cases that your parents, your teachers, your coaches, everyone we know is involved in. It's not just the high-profile stuff. It's stuff that happens every single day. And mostly this proposal is giving jurors the opportunity to have their privacy. They can still come out and speak about themselves if they are proud of what they've done. This is giving them the opportunity to have their privacy and their safety. Other things brought up was bias and corruption. It is not the media's decision whether our juries are corrupt or not. That's not their decision at all. It is still between the lawyers. The jurors are still asked Roy Dyer, which is questioning, extensive questioning at the beginning of the trial to eliminate bias. And the point is that Roy Dyer, all those questions, really intimate questions, are asked, and they are all public. Anyone can get those records. And that is my exact point. You should not be able to publish personal information such as that to the public. It is none of their information. It should be kept inside the courtroom. And again, they can come out and speak about it, speak about their decision if they wish. Someone brought up this contradicts the Freedom of Information Act. I want to bring up that there are 9 exceptions, specific exceptions to the Freedom of Information Act. 2 of them being if it invades privacy, constitutes an unwarranted invasion of privacy, or if it could reasonably be expected to endanger an individual's life or safety. So the argument brought up by the Information Act is not valid. Other things brought up, if we don't know their names, we won't know what happened in the courtroom. And the point is, even if we do know their names, it doesn't mean they'll talk about it. The Casey Anthony case, we don't know what happened in that courtroom because they don't want to talk about it, because they're being harassed. So either way, we don't know. I just want to bring up that if it was you, if it was your parents, if it was your teachers, if it was people you know, would you want their information published? Think about yourself and your family. You would not want your information out in the public for them to be harassed. This is also more of a prevention measure, as this is getting worse every single day. With the new media, with the new internet, this is getting worse. They're easier to find, and they're being harassed every single day. With that, I yield my time, and I hope you enjoy the answers.
Thank you, Delegate. At this time, that is your right.
Our legal system guarantees defendants the right to a public trial and to be judged by a jury of their peers. These rights contribute to the transparency of our legal system and are meant to protect against corruption and tyranny. If this proposal goes through, I'd like to draw your attention to line 37, where it says any juror's name from any trial, regardless if it was high profile or not. While I understand the author's intent of protecting jurors in high profile cases, this is already provided for in our legal system. And because it is, it's completely unnecessary, and it would contribute to the close legal system. One of the reasons why we are able to stand here today on the 4th of July is because we are protected from unnecessary prosecution from a tyrannical government. And this would definitely make a close legal system and contribute to a tyrannical government. And I now yield my time to my
Delegate yields minute 10.
Thank you, sir. Chair Gibb from the family of Alabama. I think the 2 most important issues concerning this debate is the safety of the jurors and the constitutionality of this proposal. So I'd like to draw your attention to a couple of points made by a previous speaker about why this proposal is unconstitutional. As stated by the previous delegate, in a 1984 Supreme Court case, the court decided that the right to a public and fair trial trumps the right to privacy of the jurors, and only in special circumstances is the privacy of the jurors outweighed by the right to a fair trial. Now, you might say, oh, well, I want to protect the safety of the jurors, but that's simply outweighed by the constitutional arguments, because the Constitution is more important than the safety of a few people, because the Constitution protects all of us and not just a few jurors. And while I do support the intent of this proposal to maintain safety, I don't agree with the technicalities in it. Thank you.
Thank you, Delegate.
My dad recently was a juror for a murder trial in Minnesota. Part of the juror selection process is that both sides try to find a jury that will either convict or absolve their client from whatever crime it may be. Part of my problem, I have one problem with this proposal, which I will address in a second. In lines 38 through 40, if you look at any person-made petition, that still violates the right to privacy. We need to protect jurors from being coerced by either side or by the general public's opinion of how to find someone in court. Everyone is presumed innocent until proven guilty. I therefore motion to read an amendment.
I'm sorry, Delegate, you did not reserve your right to make that motion. At this time, all right. Is there a second for this motion? Will the clerk please read the title of the amendment?
Remove lines 38 through 40, beginning at, quote, any, and ending with, quote, information. Is there anyone who would like me to restate the amendment?
Yes. We'll now take a vote on whether or not to hear the amendment. All those in favor of hearing this amendment, please signify by saying aye. Aye. Those opposed say nay. Nay. This motion does not carry. Thank you, Delegate. At this time, the chair.
Right to yield that remaining time if it exists to Delegate Hill.
You may.
I'm Jeff Metzger. I'm from Oregon, and I rise to oppose this proposal today simply because it is the 4th of July, and this proposal is simply unconstitutional. Let me just get down to it. As we have already gone through, court cases, the Supreme Court's precedent clearly states that the right to a fair trial trumps the right to privacy of any jurors. Also, I'd like to outline the case of Florida Star v. BJF in 1989, where the Supreme Court rules that it's unconstitutional to stop newspapers from publishing the names of things that of people who have between trials. Also, there's only 3 types of speech that the court has ruled completely that is constitutionally to prohibit: obscenity, child pornography, and threats. This proposal covers none of those, and so it is clearly unconstitutional. I believe as the youth of our nation, we have the duty to protect our Constitution, and this clearly does not do it with the First Amendment. Also, I'd like to just outline the place in the proposal where once someone gets this information, it prohibits them from publishing it on any medium. This might include forums such as Facebook, Twitter, any accounts like that. So this prohibits free speech and is clearly unconstitutional, and therefore I urge a nay vote. I now yield my remaining time to Delegate.
20 seconds.
Commonwealth of Kentucky. Thank you. My fellow delegates, I urge a nay vote on this proposal for several reasons. In order to have a fair trial, it's essential that we have a transparent jury selection process. The Supreme Court has invalidated several cases based on errors in jury selection. This creates an undue burden for the defense and post-conviction relief because they have to go to get the jury information.
Thank you, Delegate. The chair will now recognize the final pro speaker. The chair recognizes Delegate. So reserved.
We are forgetting one major point. What happens in a jury room stays in a jury room. That means that we don't know what specific jurors had which opinions. So now these jurors that may not have even agreed with the decision that was made are being harassed and getting death threats, even though they may have not even supported that decision. In addition, this is an American responsibility. Americans are called on to be on a jury. So why should they have to be in threat or feel like they are in danger because they're doing their American duty? It is ridiculous and unnecessary to provide not only names but addresses of these jurors. And In addition, there's still a process by which fair jurors are selected because the attorneys are selecting them together. And in reference to previous speakers, anyone, including the lawyers, are going to be able to petition for these names. It's not like these names are going to be kept top secret so the public can't know about it. If you have a reason to know, you can petition and the judge will allow you to hear about it. The jury does not give up their right to privacy when they are called because it is their American duty and they are asked to do it, and so we should be protecting them. It's important to protect our citizens who are doing their civil duty. And with that, I yield my time to Evans.
Delegate yields 45 seconds.
Thank you, Mr. Chair, and thank you, previous delegate. Kelsey Evans, Commonwealth of Virginia. I am in full support of this proposal and have a couple points I want to share. In 1941, in the case of Bridges v. California, Justice Black is quoted as saying, "Legal trials are not like elections, to be won through the use of the meeting hall, the radio, and the newspaper." But that is exactly what trials have become. Over the past 50 years, media attention in high-profile criminal cases has increased so significantly that finding an impartial jury and ensuring a defendant gets a fair trial is harder than ever before. And in regards to the defendant's Sixth Amendment rights, I draw your attention to the court case of Shepard v. Maxwell, in which the Supreme Court ruled the defendant's right to a public trial is not absolute.
Thank you, Delegate. The Chair will now recognize a con speaker. Chair recognizes the delegate for more. Reserved.
Alright, so I'm in opposition to this bill for many reasons, and most notably because this is against the press's First Amendment right to report on anything they want to, and against the Freedom of Information Act. Delegates, this is just a slippery slope that will continue to slip. Soon we'll be protecting the defendant's rights to secrecy. Soon, the defense attorney's right to secrecy, the judges, the prosecutor, and soon we'll just have secret trials. Guys, we need to be as public and transparent as possible. We live in a society where information is given, and in many countries this isn't so. And I yield my time to Smith, Florida.
Delegate yields 1 minute 10.
Thank you, Mr. Chair. My name is Colin Smith. First of all, I'd like to say that there's a degree of privacy, not a right to privacy, and the jury gives up that right when he's interrogated by attorneys to ensure an equal and fair trial. In the case of McDonald versus Pless, when the Supreme Court reviewed this issue, they supported that the juror does not have that right to privacy simply because they need, and the media needs to cover this case, simply because they need to show if there are, quote, verdicts can be and may be followed by any inquiry in the hope of discovering something that might invalidate the finding. So the media, by showing controversial ideas and questioning the jurors, seeing if there's something that would invalidate their decision, it is giving the people knowledge, and the Supreme Court understands that the media is of great importance to the people because it provides them with knowledge, and it would show that a verdict has bias or something that could actually trump somebody's right to a free and fair trial. Thank you, and I now yield the remainder of my time to the Chair.
Thank you, Delegate. The Chair will now recognize the pro speaker. So reserved.
Delegates, every American citizen is given the right to privacy in the Constitution. And these jurors who spend their time on these cases should have that right as well. Their right to privacy is being violated when their names, addresses, and more personal information is put out in the open, in the media, for access to anyone with anyone with access to TV, newspapers, or Google can find out about. Plus, this proposal does not take away from the jurors' ability to speak publicly on trial. They're just not allowed to speak about or release information about any other juror, which protects those other jurors as well. In response to what the previous delegate said about attorneys not being able to gain this information, it clearly states in the proposal that any person, including attorneys, may petition the court for access to these records. So I see no problem with this proposal. If anything, it just protects other citizens of this country. And I yield the remaining time to Delegate Manuel.
The delegate yields 50 seconds.
United Nations, thank you, Sir Chair. It's important to take notice of the statement which a previous delegate said. In the future, if jurors may feel pressure to change their perspective for fear of backlash. I remember watching a case coverage of a high-profile case where the defendant was clearly guilty. I claimed, what is the point of this case? We know what the outcome will be. My mom, a retired defense attorney, equally horrified by the crimes of the alleged convict, said, because that is the strength of our judicial system. It is the right of all citizens of the United States to have due process and a fair trial. That is a right that will be infringed upon if jurors' names are released and they fear backlash. I yield the remainder of my time to the chair.
Thank you, Delegate. At this time, the chair will recognize a con speaker.
I yield the remaining time of my speech to Ian from Hallman.
That is your right. Please display your placard.
This proposal, in its current form, completely dismantles the appeal process. Even attorneys are unable to access the jurors' information in review of a case. It is necessary for appellate attorneys to access jurors to obtain key facts and opinions from the jurors. Jurors are vital to the court system, not only for giving verdicts, but affecting the entire appellate system. With that, I yield the remaining time to Ian from Alabama.
Delegate yields 45 seconds. Over a minute.
Thank you, sir. Chair, Ian from the family of Alabama. I have a couple of issues with the proposal itself. First is the presentation in which the author presented the Casey Anthony trial. I find that this case, the way that she uses it, commits the fallacy of composition, because she tries to say that this one case, in which there were numerous Twitter feeds and that it gained a lot of national attention, occurs to the same circumstance for every other case, but that's simply not true. Because what she's saying is that every single juror case dealing with a murder trial, like Casey Anthony, gains a lot of media attention and that a lot of death threats. But as empirically proven, the vast majority of the jury trials in our country do not does not happen. And even if she spouts out 10 more examples, then that's not insufficient, because that doesn't show the majority of these cases. And in addition, while I definitely support the safety of these jurors, there are simply too many exclusions in which the proposal has, as stated by the questioning period. So while I support the intent of this proposal, the technicalities preclude my support. Thank you.
Thank you, Delegate. By his actions, the delegate has yielded his time to the chair, and the chair will now recognize the pro speaker.
My name is Christine Wiley, and I am from Florida. Joan Meyer, Raymond Screen, Linda Bills, Harriet White, Brian Burling, Kimberly Kimball, Kathleen Knightland, James Kern, Ronald Robertson, David Angelo, Mary Furr, and Jennifer Ford. These 12 individuals, brought together from all walks of life, now share one common bond: fear. Fear for their life and safety, and fear that those same individuals that wielded the sign saying "arrest the jury" during their trial will now act on the many threats they sent. Even with a special 3-month cooling off period given because of the controversial nature and intense media coverage of the Anthony case, these threats were still received. Belvin Perry, the chief judge of the Osceola Orange County Courts, even told the media that he wished there were some way for him to legally seal the results. He could not, and he was forced to put innocent lives at risk. One of the jurors even felt threatened enough to move to another state. This trial tore apart the lives of 12 members of the jury. We are forgetting who the criminals are. We are not respecting the jury's right to privacy and safety, and we need to wake up, pass this proposal, and do something about it. The defendants have the right to a fair trial, and when fear is allowed to influence the decision of the jury, we are not respecting that right. The records can be requested if the fairness of the trial is put into question. This proposal is simply not putting the information into the public database that puts them blatantly at risk. We need to stop penalizing Americans who are doing nothing more than fulfilling their civic duty. And with that, I yield any remaining time to the author's summation.
I'm sorry, Delegate, you did not reserve that right. This time, the chair would like to recognize the first con speaker from the floor. Chair recognizes.
It does make a little bit of safety sense to seal the jurors' names for trial, but there's a couple problems with the concepts that are assumed under the proposal. If you look at the examples that were cited, the Casey Anthony case and the UNC Chapel Hill case, in both cases, the jurors did not request that their information be kept private. And if that circumstance did occur, the judges do have power to restrict information from the public in order that none information will be given now. The problem with this proposal comes down in three main forms. One, it is already standard to only refer to jurors' private information during voir dire, which is the juror selection process, as juror numbers, and only the litigants, the defendants, and the counsels get the private information. The information can be given out, but in most cases, the judges order that it's private. If any juror feels any sort of danger or stigma association with this case, the juror will request that its information is private and is kept private. Second, there are currently Supreme Court precedents on the matter. President Coke Enterprise versus Supreme Court 1984 determined that the constitutional right of a fair and public trial trumps the right of privacy to jurors unless there is a legitimate warrant in each particular circumstance. Therefore, it is the constitutional interpretation that should only restrict the privacy information of those jurors in each particular case, depending on the case itself. Therefore, this proposal is unconstitutional for the fact that it is arbitrarily applying this idea to every single case that will be tried in the United States. Third, there are three methods for determining how information is restricted to the public. The first, the presumption of innocence. U.S. versus Talley in 1999, meaning that jurors can only be anonymous if it does not violate the presumption of innocence. In this proposal, it presumes essentially that the jurors will be in danger for convicting and said criminal. The problem with this is essentially what it does is it presumes guilty for the said defendant. The problem with this, of course, is it violates the concept of presumption of innocence in the United States. Second part of this, U.S. versus Lawson in 2008. They can restrict juror information if there's a neutral explanation and a rational reason for restricting such information, meaning the jurors are no longer biased because the defendant could be potentially dangerous. That argument is that simply the judges must explain to the jurors that their information will be kept anonymous for a neutral reason on a case-by-case basis. And finally, U.S. versus Thompson in 1985. The two reasons to restrict information for jurors are one, protection, and two, if courts take the minimal effort to minimize prejudicial effects of anonymity. Evidently, this particular proposal creates an arbitrary ruling that all juror information will be kept private. Unfortunately, that actually creates a bias in the United States and violates the right of public and fair trial. The way to go about this is a case-by-case basis that is currently available in the status quo, and in all the examples cited for this proposal.
Thank you, Delegate. At this time, the Chair would like to recognize the pro-intent speaker for this proposal.
Elizabeth Holland, Georgia Delegation. Thank you, Sir Chair. So the media will not have any access, nor will be able to petition to get the names in any way unless the jurors themselves submit it?
Yeah, I'll leave them out themselves.
Amanda Johnson, Michigan Delegation. Is it true that death threats and notes of hate were given to the jurors of the Casey Anthony case before the names were released?
Yes.
Peterson, Republic of Texas. Outside of the Casey Anthony case you mentioned, do you have any proof of any jurors actually being killed or having any physical harm done to them in any of the cases?
Yes, there's no deaths that are
Thank you, Delegate.
Thank you, Sir Chair. My name is Harrison Homer, and I am from Florida. My question has already been answered.
Thank you, Fields Pierce, North Carolina. Is or is it not true that if a jury is so pleased to provide their information to the public that they could do so under this proposal?
Yes, that's true.
Gibson Morgan, Texas. Would this proposal remove jurors' names from public knowledge?
Yeah, unless they come out themselves.
Thank you.
Go to DC Delegation. How will you ensure the protection of the jurors?
And it'll be illegal to publish their names.
Kayla Harry, Tennessee, the volunteer state. Are witnesses in trials, are their identities protected?
That is not included in this proposal.
Mason Hill, Kentucky. Would any attorneys working to gain post-conviction relief for a defendant be able to get jurors' information?
They can only get their information if they petition for it and have a logical reason.
Further questions? Chair recognizes the delegates from Florida, Louisiana, North Carolina, New York, New Jersey, Kentucky, Washington.
Thank you, Sir Chair. My name is Kylie York, and I am from Florida. Where is the information of the jurors published?
It's true for all the usually public or text, I guess, or public records.
Thank you.
Thank you, Chair O'Brien, North Carolina. How would the jurors be reviewed for diversity and unrelatedness to the case?
They're still chosen the same way as they always are when the lawyers.
Will the authors please speak closer to the microphone?
Sorry, they're decided as they usually are before dire, not too many questions beforehand.
Congress with the delegation. Thank you, Chair. Could you briefly state a couple other cases where similar incidents have occurred?
Yes, there was a UNC Charlotte student murder trial in Gastonia, North Carolina, and the McHenry battery.
Thank you, author.
Matt LaFrance, New Jersey. What is defined as good cause for the
for the release of the jurors' information?
If there is necessary, there has been a trial in the previous trial, or there is bias or something like that.
Amelia Cobb, Kentucky, Sir Chair. What will be the punishment to a juror if they release information about another juror?
That's not included in this proposal.
Thank you, Chair. Lauren Miller, North Carolina. Are the decisions of individual jurors released or only the collective verdict?
Sorry, can you repeat that?
Are the decisions of individual jurors released or only the collective verdict? Can they be released? Right.
No.
Andrew Reed, Washington State. Is this only for high-profile cases?
No, it's for all cases.
My question was answered.
Further questions from the floor? The chair recognizes delegates from Oklahoma, Louisiana, Massachusetts. That's it, guy.
Choate, Oklahoma, will licensed attorneys be able to contact these jurors and review the cases?
Sorry, can you repeat that?
Will licensed attorneys be able to review the case and get a hold of the jurors?
They can get their names and information the same way as everybody else.
Jasmine Miller, Louisiana. Will this proposal do anything about public records of previously released jurors' names?
No, it doesn't affect previous releases.
Benjamin Quinn, Commonwealth of Massachusetts delegation. Is it true that in the cases in which people were threatened, their names were only released, not their positions in the actual trial?
127 of battery. Yeah, I still have 2 hours of battery.
Owens, Oklahoma. Who exactly is allowed to petition for the release of the information?
Anybody named Howard.
With that, the time for non-debatable technical questions has elapsed, and the chair. The author is recognized for a 4-minute opening statement. You may begin when ready.
Thank you, Mr. Chair, Delegate Hallman, North Carolina. Last year, 325,283 tweets were sent around the time of the case of Anthony's verdict, and many were surprised to hear she was found innocent. This is proof that in our new age of technology, we face new problems. The issues surrounding juror privacy are new to everybody, and the law must be made to prevent juror harassment. In the case of Anthony case, millions watched the 33-day-long trial live on TV, and afterwards, before people even knew the names of the jurors, they started handing out death threats. Once they were released, reporters and others bombarded the homes and workplaces of 12 jurors. One woman had to move from Florida to Michigan, leaving her life behind to avoid judgment and harassment from her coworkers. These jurors were so easy to find because their names, addresses, and other personal information was made public. With the click of a button, even I can find all of their names. High-profile cases such as this are becoming interactive for the public, who watch and comment in real time and who become enthralled with the case. Sometimes people such as this start to take cases too personally. There is no reason that random citizens, including criminals and mentally unstable citizens, need to know the names and addresses of jurors. Once the case is over, nothing can be done to change it, and knowing personal information helps nothing. It only causes more problems. As this is a recent problem, action should be taken to prevent this issue from escalating into something uncontrollable. Although we only hear about the high-profile cases, this happens frequently on a local level, and in the future, fear of public backlash may begin to influence the jury's decision. Innocent citizens simply viewing the disease as a mere should not be intimidated, pestered, or forced to move their problems. It is hard enough to find people to serve on juries without them having to fear for their safety. This shall change the way courts are effective from here on out. By stealing juror names and information and keeping them confidential, this policy can make the objection. I know my time to closing summation.
The author yields 2 minutes to her closing summation. At this time, the floor